Hello students, welcome to the lecture on Federal Court System. After this lecture, we will be able to learn the following objectives. Understand the court system in the US. Explain the national judiciary. Describe the inferior courts. Explain how federal judges are chosen. Explain the Supreme Court. Court system. The federal courts are the third branch of the government of the United States of America. The federal court system is created in the US Constitution. The United States Constitution was finalized in 1788 and is still the supreme law of the land. It was based on the principle that all people have the right to life, liberty, and pursuit of happiness. The Constitution protects the sovereignty of each state while mandating that they are unified as one nation. Let us now understand the authority of the branches. The power of the federal government was balanced among three equal branches to create a long-lasting government that would serve everyone. The three branches are the executive, legislative, and judicial branches. Americans vote to elect the members of the executive and legislative branches. The members of the judicial branch are appointed by the President and confirmed by the Senate. Let us take a look at the Supreme Court's power. The Supreme Court of the United States is the highest court, and all lower courts are obligated to follow the guides set by the Supreme Court when making decisions. Now we shall take a glance at the lower courts, district courts, and the courts of appeals. District courts handle most federal law cases. The US Courts of Appeals review the appealed district court cases. Let us now learn the difference between the state and federal courts. Each state has its own court system. State courts have hierarchy levels, with the highest level being the state's Supreme Court. Federal courts make sure that state laws obey federal laws. Okay, now you have a good understanding of the American judicial system. Did you know that Congress determines the number of Supreme Court justices? There have been as many as 9 and as few as 6. Look at this video here to get a better understanding of the court system in the United States.
Some people would say that the federal system is the highest system. That's in some ways true, but the federal system generally deals with larger disputes, larger civil disputes where a lot of money is at stake, or very serious federal crimes. The state system is much larger and handles many, many more cases per year. And the state system is the system that most people will come into contact with. Even more people will come into contact with the local system, the municipal courts, small claims courts, traffic courts, family courts. It can be somewhat confusing, but there are a number of courts that are operating at the same time. And then within any particular system, for instance, within the federal system, there is a hierarchy of courts. There's the district court, which is where the trials occur. If someone doesn't like the verdict there's a court of appeals that the case can be appealed to. And then there's, of course, the United States Supreme Court, which is the highest court of the land. And there's a similar system of levels of courts in the state system and in the local courts as well. Once you're in one system, you stay in that system until you've exhausted that system. You don't jump between the state and the federal courts, with very, very few exceptions. There would be an exception in a criminal case on occasion if you've gone to the highest court of your state court. Again, this would apply to very few people because it would involve a very serious crime. Then, on occasion, you could go to the federal system. But as a general rule, you work your way up in the system that you're in. However, fewer than 5% of all cases get from the bottom level to the top level. It's very, very few. You can think of it as a pyramid. The lowest court handles a large number of disputes, and then a few come up to the next level, and then fewer still come up to the highest level. Most people resolve it at the lower level.
National Judiciary Independence Hall. Philadelphia, one of the most recognizable buildings in the United States. To all Americans, it stands as an icon of liberty and freedom. The system of government our founders created is described in the US Constitution, which was drafted here in 1787. The US Constitution sets the framework of our government and protects each citizen with certain rights and privileges. Each state has its own constitution. In fact, the original 13 colonies each had constitutions in place long before the US Constitution was written. Pennsylvania's constitution today sets up our state government in 3 separate branches. The executive branch, which is headed by the government, the legislative branch, which is known as the General Assembly and is made up of 2 groups of elected representatives, the Senate and the House, and the judicial branch, which is guided by the Supreme Court. Our focus here is on the judicial branch, that is, our court system. Let us look at the courts and how they work to protect your rights. Rights like equal protection under the law, which means everyone has the same protected rights. Due process, which means, among other things, that you have a right to a fair and public trial. Habeas corpus, which means you cannot be kept in jail without being charged with a crime. And the right against self-incrimination, which means in a court of law, you do not have to say anything that might be used against you. Basically, what all this means is that you have a guarantee of open and equal access to the courts. You have an opportunity to be heard and to have your case decided either by a jury of your peers or by a judge sworn to render decisions without fear or favor. Here are the stages of the American judicial system. The first step is the complaint. The complaint is immediately recorded by the police and then referred to the prosecutor's office. At this stage, a judge decides if the accused is to be remanded in custody or released on bail. If the accused pleads guilty, an agreement is made between the defense and prosecution on a lighter sentence. If not, it is referred to the grand jury. The grand jury is made up of 16 to 23 members of the public who listen to the arguments of the prosecutor and possibly those of the alleged victim and the accused. After deliberation, they decide whether the case should go forward. The official indictment is served by a Supreme Court and the trial is the last step. Appointment of judges. It is the President who nominates people to fill all open federal judgeships, including those on the Supreme Court, and presidents naturally tend to choose possible judges who agree with them philosophically. The 2 lower tiers of federal courts have authority over specific geographic areas, and because senators differ to each other's preferences when deciding to confirm a proposal, presidents typically consult with the senators who represent an area before appointing judges to it. That is not the case when Supreme Court justices are appointed, as their jurisdiction is national. The inferior courts. The Congress acted in the Judiciary Act of 1789 to create inferior courts. 13 district courts were constituted to have 4 sessions annually, and 3 circuit courts were established. The circuit courts were to consist of 2 Supreme Court justices each and 1 of the district judges, and were to gather twice annually in the various districts comprising the circuit. This system had substantial faults in operation. The burden imposed on the justices, who were required to travel thousands of miles each year under bad conditions. Despite numerous efforts to change the system, it persisted, except for one brief period until 1891. Since then, the central judicial system has consisted of district courts with original jurisdiction, middle appellate courts, and the Supreme Court. District courts. there are 94 US district courts in the United States. Every state has at least one district court, and some large states such as California have as many as 4. Each district court has between 2 and 28 judges. The US district courts are trial courts or courts of original authority. This means that most federal cases begin here. US district courts hear both civil and criminal cases. In many cases, the judge determines issues of law while the jury determines answer of fact. The federal court system includes 94 district courts in the 50 states: Washington, D.C., Puerto Rico, Guam, US Virgin Islands, and Northern Marinara Islands. District courts generally have jurisdiction to hear cases involving central law and those involving citizens of different states. If a party in a state case can prove that a federal district court has jurisdiction to hear a case, the party may remove the case to the federal court. However, the federal court may abstain from hearing a case that involves questions of both federal law and state law. A situation may also arise where a federal district court may no longer have authority to hear a case because of changes in the parties to the suit. If a case has been removed to federal district court and the federal district court lacks jurisdiction, the court on motion of one of the parties will remand the case to the suitable state court. The Courts of Appeals Congress, through the Judiciary Act of 1891, originally established the intermediate appellate courts in the federal judiciary to lessen the caseload on the Supreme Court justices. Prior to 1891, cases were appealed routinely to the Supreme Court, which was required in most cases to hear the appeal. The Courts of Appeals now have jurisdiction to hear appeals from the federal district courts in almost all cases. Unlike the Supreme Court, Courts of Appeals do not have discretionary jurisdiction to make a decision whether to grant an appeal. The federal court system currently consists of 12 regional circuits, each with one court of appeals. 11 of these circuits are numbered. The 12th circuit, the Court of Appeals of the District of Columbia, governs only Washington, D.C., but here's a number of cases involving federal agencies. Congress in 1982 created the United States Court of Appeals for the Federal Circuit, which combined the functions of the United States Court of Customs and Patent Appeals and the United States Court of Claims. Let us hear about the Pennsylvania state government's judicial system.
If there is one single symbol of Pennsylvania's state government, it is the Capitol in Harrisburg and its rotunda where I'm standing. This is the formal seat of all 3 branches of government, including the judicial branch. To better understand Pennsylvania's court system, let's take a look at the Judicial Pyramid. At the bottom of the pyramid are the courts that hear civil cases involving small amounts of money and some criminal matters. Typically, these include magisterial district courts, the municipal courts in Philadelphia and Pittsburgh, and Philadelphia Traffic Court. The next level on the pyramid is the trial level, which in Pennsylvania is called the Court of Common Pleas. These are the courts where many cases begin, where you may be called to serve as a juror, and which you often see portrayed on television. In Pennsylvania, this is where the DAs from Law and Order might prosecute you. Your divorce would be heard, or you might adopt a baby. Not satisfied with the ruling of a trial court, depending on the type of case, you likely can appeal to the next higher court level, to the Superior Court, or perhaps to the Commonwealth Court, when issues of government law are concerned. At the top of the pyramid is the Supreme Court, the highest court in Pennsylvania. The justices here, and they're called justices at this level, not judges, the justices are responsible for supervising and coordinating the administrative work of the entire court system, and they sit as our court of last resort, the place for final appeal of decisions by lower courts. Of course, every day our courts must hear and decide cases involving disputes and controversy about those who have been injured or those who have become victims. A person sues another person. Someone is charged with a crime, or legal problems arise involving families or children. Win or lose, the point remains the same. American courts strive to be accessible, and American judges and juries work hard to be fair. Now let's drill deeper and find out exactly how Pennsylvania's courts work. To describe the trial courts, we turn to Judge Kim Berkeley Clark.
The beauty of Pennsylvania's judicial system, as is true all across America, is that our courts are designed to be free of external influences. Judges strive to maintain this judicial independence not as a means of wielding power, but as a way to guarantee that the rights of all are protected. Our decisions are guided by legal precedent and are based entirely upon our application of the law, nothing else. We are trained to be fair, impartial legal arbiters. The reason we're set up that way is to provide you and every citizen with a voice. If you have a grievance or a need to defend yourself against a grievance, you can have your day in court and get it resolved. Our court system is accessible to all. Many cases begin here in the trial courts, called the Courts of Common Pleas. Every one of Pennsylvania's 67 counties is served by one or more trial judges. Trial courts have what's called general jurisdiction, meaning that they handle all types of cases, including criminal cases ranging from nonviolent crimes like theft to the most serious offenses such as murder, civil cases such as contract disputes, lawsuits involving businesses, personal injury, or settlement of estates. Sometimes these cases are heard by citizens sitting as a jury, and sometimes before the judge alone. Trial courts also handle family cases in which judges must address very personal issues like child custody and support, adoption, divorce, and the distribution of assets between spouses. Judges in trial courts also hear abuse cases and issue protection from abuse orders. Any person who loses a case in a trial court has a right of appeal to one of Pennsylvania's 2 intermediate appellate courts. Here to tell you about the appellate process is Superior Court President Judge Kate Ford Elliott and Commonwealth Court President Judge Bonnie Ledbetter.
Most of us are somewhat familiar with the way trial courts work. We see it in courtroom dramas all the time. Not that everything you see is real, of course, but you know the main players. There's a judge, a jury, a prosecutor, and a defense attorney, along with the court staff and the gallery. But not as much is known about the appellate courts. Appellate means appeal in Latin. When a person loses a case at the trial level, they can appeal the judge's decision to an appellate court. The first level of appeal is taken to one of Pennsylvania's 2 intermediate appellate courts, either the Superior Court or the Commonwealth Court.
Choosing federal judges. Let us now find out how federal judges of the United States of America are chosen. There are 3 different methods of choosing judges in this country. The first is the appointment method, in which the decision-making of the state nominates an individual to become a judge, and the state senate must confirm the nominee before he or she takes office. This is the method followed by the federal government and by 11 states. The second method is known as retention elections, in which the executive will appoint a judge to the bench, and then after a certain term, voters are asked whether or not they want to retain the judge. The judge is the only candidate placed on the ballot, and the voters simply vote yes or no as to whether the judge should serve another term. If the judge is voted out of office, the governor will appoint another judge to begin the next term. 17 states use the retention election system for at least some of their judges. Finally, there are contested elections in which Judges run for their seat in more or less the same way that other elected officials run for office. They are chosen by a party and then they run against a nominee from the other party in the general election. If elected, they serve their term and then must run for re-election against another challenger. The remaining 22 states choose their judges through the competitive election system. The President and his closest political and legal aides, especially the Attorney General, take the lead in selecting federal judges. Presidents use a number of criteria in selecting their nominations. Political ideology. Presidents usually appoint judges that seem to have a similar political philosophy to their own. In other words, a president with a liberal ideology will usually employ liberals to the courts. The same goes for conservative presidents. Party and personal loyalties. A remarkably high percentage of a president's appointees belong to his political party. Although it is not as common today as it once was, presidents still appoint friends and loyal supporters to federal judgeships. Acceptability to the Senate. Because the Senate must confirm judicial nominations, the President must consider candidates that are acceptable to the Senate. Even if he does not informally consult with the Senate, he may still run into problems with the Senate Judiciary Committee, who first interrogates nominee and recommends them to the full Senate. Judicial experience. Typically, justices have held important judicial positions before being nominated to the Supreme Court. Many have served on courts of appeals and others have worked for the Department of Justice. Some have held optional office and a few have had no government service but have been distinguished attorneys. Race and gender. The first black American, Thurgood Marshall, was appointed to the Supreme Court by Lyndon Johnson in 1967, and the first woman, Sandra Day O'Connor, was appointed in 1981 by Ronald Reagan. Since then, one other black, Clarence Thomas, and one woman, Ruth Ginsburg, have been appointed as well. Before 1967, all justices were white and male. The percentage of women and minority federal judges appointed has increased significantly in recent years. The Supreme Court. The Supreme Court is the highest court in the United States and the chief authority in the judicial branch. The number of justices serving on the court is determined by the Congress rather than the Constitution. But since 1869, it has always consisted of one Chief Justice and 8 associate justices. They are appointed by the President for life. Supreme Court justices are the only judges granted the title of justice. They are confirmed by the Senate and protected by the Constitution. The US Constitution, Article 2, Section 2, Clause 2 states that the President shall nominate and by and with the advice and consent of the Senate shall appoint judges of the Supreme Court. Interestingly, the Supreme Court, though not a trial court, has both original and appellate jurisdiction. Only 2 classes of original jurisdiction cases are heard: cases in which a US state is a party and cases that involve ambassadors, public ministers, and consuls. Its appellate jurisdiction is exercised far more frequently, with cases originating from petitions for reviews of lower courts' decisions. Of the 4,000 to 5,000 cases appealed to the Supreme Court each year, only 75 to 200 are heard. If 4 of the 9 justices believe errors in procedure occurred and vote to hear the case, it is granted writ of certiorari, meaning made more certain. The Supreme Court also hears cases by certificate when a lower court asks for a ruling or clarification on a case. Though these cases can be heard with the approval of 4 justices, most are denied based on stare decisis, which translates let the decision stand. Other appeals are returned to the lower court on brief orders, directing the lower court to reconsider the case in light of a new Supreme Court decision that applies to the case. All 9 justices preside over accepted appellate cases. Each party presents a document presenting the facts of a case, then summarizes the lower court's decision and argues an opinion. Occasionally, the court grants 30 minutes oral arguments to each party before convening to discuss the case and hand down an opinion. There are 3 types of opinion that the court can hand down. A majority opinion states that the decision of the court and requires a majority of the justices to agree on the decision. If a justice voted with the majority but disagrees with the legal reasoning of the majority opinion, he or she can offer a concurring opinion. Justices who do not vote with the majority can offer a dissenting opinion, which states why a justice in the minority voted against the majority. If a similar case is put before the court and the justices consider reversing an earlier ruling, dissenting opinions become critical. For example, Justice John Harlan's dissenting opinion in Plessy versus Ferguson became the basis for the reversal of the separate but equal doctrine. Let us find out more about the Supreme Court of the United States of America from this video.
3 branches of the federal government in the United States: executive, legislative, and the judicial. The Supreme Court represents the ultimate branch of the federal judicial system. The Supreme Court does not enact laws, but is instead responsible for interpreting the law and determining if federal law meets constitutional standards. The court consists of a Chief Justice and 8 Associate Justices, nominated by the President and confirmed by the U.S. Senate, who serve life terms once confirmed. Those terms only expire when a justice retires, resigns, dies, or is removed via impeachment. For all that we understand the High Court to be, the Constitution itself doesn't give much guidance. Under Article 3 of the Constitution, there are no specific guidelines, duties, nor responsibilities of this court. It only says, "The judicial power of the United States shall be vested in one Supreme Court and in such inferior courts as the Congress may from time to time ordain and establish." Those inferior courts are the federal district and appellate courts placed geographically around the United States to handle regional federal issues. And while the Supreme Court doesn't itself make laws, its rulings have far-reaching effects on American freedom and jurisprudence. In its entire history, the U.S. Supreme Court has only had 16 Chief Justices. The very first Supreme Court was established in February of 1790. Its Chief Justice was John Jay. The current Chief Justice is John Roberts. Because of the Chief Justice's longevity, each court's rulings are defined within the era. John Marshall, Warren Burger, and Earl Warren all had a significant impact on the American landscape by the rulings that were handed down when they served as Chief Justice of the U.S. Supreme Court. For instance, the Warren Court, which covered an era from 1953 to 1969, ushered in the U.S. Civil Rights era and expanded civil rights, civil liberties, and the reach of both judicial and federal powers in the U.S. And though the Supreme Court is supposed to be apolitical, that is, you're not supposed to know the political affiliations nor leanings of any particular justice, each justice is appointed by the sitting president and, as such, becomes a political flashpoint during confirmation hearings. Notable controversial hearings included the nomination of Robert Bork, who was rejected for confirmation in 1987 on largely ideological grounds. Other nominees to be rejected: Harold Carswell and Harriet Miers. Most presidents are lucky to nominate 1 or 2 Supreme Court justices. The president to appoint the most: George Washington, who appointed 10, and Franklin Roosevelt, who nominated 8. Thanks for watching our profile of the Supreme Court.
Summary. Now in the end, let us summarize what we have learnt in this lecture. The federal courts are the 3rd branch of the government of the United States of America. The central judicial system consists of district courts, middle appellate courts, and the Supreme Court. The President nominates people to fill all open federal judgeships, including those on the Supreme Court. The Congress acted in the Judiciary Act of 1789 to create inferior courts. 13 district courts were constituted to have 4 sessions annually, and 3 circuit courts were established. There are 94 U.S. district courts in the United States. The federal court system includes 94 district courts in the 50 states, Washington, D.C., Puerto Rico, Guam, U.S. Virgin Islands, and Northern Marinara Islands. The federal court system currently consists of 12 regional circuits, each with one court of appeals. The Supreme Court is the highest court in the United States. Since 1869, it has always consisted of one Chief Justice and 8 Associate Justices.